There are several international protocols that can offer leverage to indigenous peoples' claims to strike their own bargains with extractive companies. In 2007, the UN General Assembly passed the Declaration on the Rights of Indigenous Peoples, which says that indigenous people have the right to self-determination and to free, prior, and informed consent over the ownership, control, and use of their land and natural resources. Relocation should take place only with free and informed consent. The UN resolution was passed by a vote of 143 to 4. The 1989 ILO's Convention 169 on Indigenous and Tribal Peoples, Article 15 states, "The rights of the peoples concerned to the natural resources pertaining to their land shall be specifically safeguarded. These rights include the rights of these people to participate in the use, management, and conservation of these resources." The IFC Performance Standard 7 requires, among other things, engagement such as stakeholders analysis and planning, information, consultation, and participation in a culturally appropriate manner. Engagement should involve the group's representatives, organizations, and other individuals, and allow for sufficient time for decision-making. It requires explicit analysis and discussion with the community about the use or development of and risk to the land and resources. And the Equator Principles, which many financial institutions, like banks, use to manage their risk. These require companies requesting loans to seek informed consent and participation and to protect vulnerable indigenous populations. But usually when people discuss the rights of indigenous communities, they talk about FPIC, free, prior, and informed consent by indigenous people, which gives them input into the decision and method by which extractive companies can develop a project on their land, among other things. So why are there problems? While it sounds straightforward enough, FPIC sets up a collision between the rights of the state, which claims to legally control all subsurface resources, and the rights of the indigenous people to ownership, use, and control over their land and resources. Why does FPIC break down? First, there's disagreement about the meaning and extent of what it means. Many states, companies, and other institutions claim that FPIC does not require unanimity. It means consultation with a group, and can be considered achieved even when people within the group disagree with a decision. They say FPIC is not a veto. This perspective is not shared by many indigenous groups and has led to legal cases and violent conflicts in some situations. Second, it's voluntary. The UN Declaration does not have the same power as international law. Third, there is uneven application and interpretation from country to country, and even within countries. Some countries have their own policies and laws dealing with indigenous rights which differ from FPIC. Fourth, it isn't adopted by that particular country. Fifth, companies and/or governments operate with a lack of good faith. They may not accept the alternative processes of the group, or they may deliberately misinform the population, or they may decide not to enforce the rule. Sixth, there are implementation problems or gaps that make it difficult to bridge what the national laws and policies say and what can be or actually is applied in the field. Seventh, there are disagreements about who or what group is an indigenous people. And eighth, there is corruption that leads companies or governments to try to circumvent the process. In some countries, FPIC is part of the national law, so communities should always investigate laws, policies, and legal precedents in their own country. For example, the Philippines gave indigenous communities the right to self-determination in 1997. It has its own processes and rules for seeking consent. But even when accepted by a country, there can still be discrepancies about what FPIC means or allows for and how it is implemented.